Hey guys, welcome to this video. My name is John Watts. I'm a consumer protection lawyer, and for many years we've been suing debt collectors and credit bureaus and companies that furnish information to credit bureaus such as a credit card company, mortgage company, and we sue them for false credit reporting. And we almost always make a claim for mental anguish. And I can't think of one case where this is not true. Okay? Every single case, the lawyers come back to us and they say, well, we didn't do anything wrong. But if we did anything wrong, I mean, your people, they can't get any mental anguish damages for this. You know, they weren't physically hurt. You have to be physically hurt, like a car smashing into you, to get mental anguish. Well, I've been doing personal injury cases for 25 years, so I'm pretty aware of mental anguish, pain and suffering when we have a physical injury. But that is not a requirement, at least in the state where I practice, and in most states it's not a requirement to have a physical injury. And let's just think about this outside the scope of law, just our own personal experience, because after all, that's what jurors are told in jury charges. Use your good common sense, your own experiences as you evaluate things. So, can we have emotional distress? Can we have mental anguish and there not be a physical injury? Well, of course we can. We might be in a partnership, a business partnership, and our partner betrays us. Well, they didn't physically hurt us, but that may be devastating. That may send people spiraling into depression. It could be a friend betrays us. It could be just somebody says something so hateful to us or to our children or our family members. And we say, I'm just really deeply cut by this. And so we know from our own experience, we can have mental anguish without physical injury. So when we sue somebody for false credit reporting, and they go, well, John, you can't possibly have mental anguish unless there's a physical injury, and we sort of get rid of that, then they go, okay, well, only if you can prove that this lowered your score so that you did not qualify for a loan. Only then can you get mental anguish. Go, really? Why is that? They go, well, it has to make a difference. Well, what they're doing, either intentionally or unintentionally, is they're merging two concepts. They're merging economic damages with emotional distress. They're saying, well, only if you did not get that home loan, or maybe you had to pay a higher interest rate, can you then have mental anguish, emotional distress? No, those are two separate things. Now, they can combine, certainly, okay? So clearly, if I'm, one day from closing on my house and Bank of America or some debt collector puts something false on my credit report, and then I'm not able to close and I lose this house, yeah, obviously that's upsetting, okay? But I don't need to have that economic loss to have mental anguish. Just the fact that somebody has put something false on my credit report, that's upsetting to me. Just like somebody put a billboard up and said, sort of plug your name into here, you're a child abuser. Okay? Well, if that's not true, is that upsetting to you? They go, well, but can you prove that you lost your job because of that? No, it's just very upsetting to me that you would say that. Okay? And so if I have false credit reporting and I've disputed it and they don't fix it, even if it doesn't impact my FICO score, even if it doesn't impact my ability to get that loan, it still can be very upsetting to me because that's my credit report. Okay? So I'll give you an example. So for many years, we have sued debt collectors under Section 1692E8. So 1692, that's the Fair Debt Collection Practices Act. And then the Section E has to do with misrepresentations, deceitfulness, just lying, okay? And then it gives a whole bunch of examples. And subparagraph or subsection 8 says that a debt collector that provides false information on your credit or that they should know is false, that violates the law. That makes sense. But it also says the failure to mark an account as being disputed. That violates Section E8. So we sue debt collectors all the time for this because we tell them verbally we dispute it. We type them a letter that says we dispute it. and then they update our account and they don't mark it as disputed. So we sue them and we say, hey, we have mental anguish. They go, John, you can't have mental anguish. Well, first of all, it's always amusing to me that the lawyers that tell me this, I go, so tell me how many jury trials you've tried under the Fair Debt Collection Practices Act. And let's make it more specific, under Section E. How about under E8? Well, these cases don't really try, John. Everybody knows you can't get emotional distress for this. And I go, okay, so you've never tried a case, and now it's everybody knows? Well, who is everybody, and what do they know, okay? So the fact is, we have tried cases under the FDCPA and under Section E. So we've tried cases involving life. We understand about mental anguish, okay? And this also goes back to my personal injury days where we're trying fraud cases. There's no physical injury, but we're trying fraud cases getting mental anguish. So that's what they say. And then when we kind of raise the point that, you're talking to me and you have no idea what you're talking about, they go, well, I just don't see how anybody would award these damages. Well, again, we go back to, you have no experience in this. And you're telling me what our jury that we haven't seated, you're telling me what our jury will do, okay? But let's put all that aside. Just think about it for a second. I dispute with that debt collector, and that debt collector has an absolute obligation, if it updates my report, to mark it as being disputed, and it absolutely refuses to do that. Can that be upsetting to me? Well, absolutely. They go, well, it didn't affect your FICO score. It actually does, okay? People who say that just don't know what they're talking about. But even if it doesn't affect our FICO score, even if it doesn't cost us a loan, the fact that my credit report is damaged, that it is not showing as disputed when it should show disputed, now that affects me because maybe I want to go get credit tomorrow. Maybe I want to apply for this job next week or next month. And I've got this. It's there in the back of my mind. And even if I'm not applying for credit, not applying for a job, no security clearance, look, I didn't choose that there be a credit report on me. But if there's a credit report on me, it better be accurate. And the fact that some debt collector over a $50 charge or a $500 charge or a $5,000 charge says, you know what, we know what the law is, we're not going to follow it. Why wouldn't that be upsetting to me? Of course it's upsetting to me. Of course this is mental anguish. Of course I have emotional distress. Now, is that a little bit or a lot? Guess what? That's up to the jury. That's not for some defense lawyer defending debt collectors say, well, John, I know your client has no mental anguish. Wow, you're a genius to know that. How could you possibly know that? Okay. And frankly, it's not for a judge to say, well, John, I've decided that your client, it is impossible for them to have mental anguish. How would you know that, Judge? We have to have testimony on this. Okay. Now, the judge, if the judge is the trier of fact, that's a bench trial, or the jury might hear the testimony and say, we don't think this rises to the level of mental anguish. That's fine. Just like in a car wreck. I may say, look, and frankly, when we try car wreck cases, we don't put the medical bills in. That's something that, we did years ago, but go back in time and say, we claim the medical bill. There's $10,000 in medical bills. Can a jury just award us our medical bills? Can they decide not to award us for pain and suffering, mental anguish, emotional? Sure. They might decide we haven't proven that. But that's the key word, is proven it. Okay. So when we're bringing a claim against a debt collector under Section E8, we're bringing a claim against a debt collector under the Fair Credit Reporting Act, or a credit card company under the Fair Credit Reporting Act, or a mortgage company under the Fair Credit Reporting, whatever the consumer law is, and we're claiming emotional distress or mental anguish, we have to be careful as lawyers that we don't let the other side distract us or discourage us from this when they start going, well, John, there's no way that you can win. What does this lawyer know? Okay. How many cases has this lawyer tried? How many focus groups has this lawyer done? Okay. So we can't be discouraged by that. And we have to say, you know what? It's out there, and we'll leave it up to a jury. We'll let a jury decide what that mental anguish is worth. Now, we have experience and we've done a bunch of these cases, so we have a pretty good idea of what juries will do, and we've done focus groups. But the point is, and I know I'm kind of going long in this video, but my point is this, take home message is, if you have had the law violated against you or your client, and your client honestly, legitimately says, you know what, this is upsetting to me. I mean, I look around and, I follow the rules. I stop at the red lights, whatever it is. And here this debt collector that they didn't ask me if they could put this on my credit report. And I dispute it. And they willfully, intentionally refuse to mark it as, they won't mark it as disputed. Or they say, oh, well, when I got your letter saying I dispute this debt, we didn't know that that dispute means that you actually dispute. So they can say, oh, well, this was just an accident. But look, it's bogus, okay? They know what the law has been the law since the 70s. When they violate this law, of course that would be upsetting, and get the compensation that you deserve for that. Okay, guys, thanks for watching this, and I'll talk to you soon. Bye-bye.